Please be seated. Good morning, everyone. I understand that before we get started, there may be a motion for us to address.
For the lawyers present, don't panic. There's no motion for you. I move to have all of our law clerks that pass the bar come forward and be sworn in and be admitted to the bar. You can relax.
Will the soon-to-be lawyers please approach? Right up and spread out, please. And if your families want to take some pictures, they should feel free to do so. Okay.
That's it.
All right. Please raise your right hand. I, and state your name, do solemnly swear that I will support the constitutions of the United States and of this state, that I will honestly demean myself in the practice of law, that I will discharge my duties to my clients to the best of my ability, and that I will conduct myself with integrity and civility in dealing and communicating with the court and all parties. So help me God. Congratulations to all of you. We're honored to have you with us.
Just turn around so we can take pictures.
Turn around, face your families, face the cameras. For those who are interested, we have another swearing in on, I believe it's next Monday, of all the other lawyers in the state who passed the bar. We wouldn't have a civilization without them, and we appreciate very much everything that they've done and the hard work they put in to pass the bar. For the families who are present, we're going to invite you to come up after we finish these two arguments. Your children will tell you where to go. We'll shake hands with you, and we'll sign your oaths to make sure you're official. Okay. Thanks, everyone. With that, we're going to move on to official business. Counsel, thank you very much for your cooperation and patience. With that, I'm going to call our first case for oral submission this morning, PD 0284-25, Bobby Carl LENNOX, also known as Bobby Carl LENNOX, LEANOX versus the state of Texas. I believe we'll hear first from counsel for the state. As counsel approaches, if they could speak clearly into the microphone and remind us of their name and who they represent, I'd appreciate it.
May it please the court. Counsel, Mr. Hornsby. My name is Jeff Shell. I am here once again as a special prosecutor, this time for Lamar County, Texas, and its recently appointed County and Criminal District Attorney, Nick Stallings. If there's one salient point I'd like to make this morning, it is this, that the state acknowledges that the value ladder in subsection E1 of the forgery statute is an element of the offense, as this court's previously said in 2024 in Green and LENNOX versus the state of Texas. This is 682 Southwest 3rd at 253. Former Judge Michelle Slaughter wrote an 8-0 opinion with Judge Erie concurring, and in that opinion the court essentially said that subsection E1, which the legislature in 2017 added to the forgery statute, was an element of the offense. It is not, as I argued in 2020, 2020, by Zoom during the height of COVID, that E1 was meant as a punishment issue. The court clearly did not adopt that statutory construction and instead said it was an element of the offense. So if it is an element of the offense, when is it supposed to be raised? And in this case, which is now before the court again, this is its second time to come up through the appellate ranks. When is 3221 the value ladder? And I'm going to refer to 3221 and the value ladder synonymously throughout this argument. It means the same thing. If I interpose the two, I apologize. But for all practical purposes, E1 is what is at issue. And when is E1 supposed to be raised? In this case, if the court looks at the indictments, and the indictments are set forth in the clerk's record, pages 6 through 7. And by the way, this indictment is file stamped February 14th, 2019. These cases were indicted in February of 2019, and this indictment does not incorporate subsection E1. It went to trial under 3221 subsection D, which at that time, D said it was a state jail felony to forge any writing that included a commercial instrument, a check, a will, a codicil. They're all listed in subsection D. At no time during the trial or the pretrial proceedings of this case did Mr. LENNOX ever raise subsection E1 as an element that was defective and left out of this indictment, nor was E1 ever raised at a jury trial conference, at a pretrial conference, in a motion to quash this indictment. At no time was it raised. So for the Court of Appeals now twice in Texarkana to send this case back for a new trial on punishment without even E1 ever being raised is contrary to Marin. It's contrary to everything that I have ever learned about preservation of error and under Rule 33.1A.
So I have several important questions, right?
Of course.
Yes. First of all, the trial judge has a duty to instruct the jury on law applicable to the case.
Yes, 3614.
And you're saying that subsection E1,
Yes.
you've said it a couple times, you said that it's an element of the offense.
Yes, now we know that.
So if it's an element of the offense, then it seems to me that it looks an awful lot like law applicable to the case. But if you view it as an element of an offense, maybe one distinct from the one that was being tried at the time, then it might not be law applicable to the case unless the defense brings it up somehow.
Correct.
So that would say that if you're making that argument, that I'm trying to understand it because I keep hearing you say the offense, and maybe it's because LENNOX said something like that. Maybe that's leading you down that path. But again, that was COVID, so who knows?
Lead me
who knows
however
whether we
you
made
want
mistakes.
me to be led.
So anyway, that seems to me to be one of the most, if not the most important question. Is this a instruction on, is E1 law applicable to the case, or is it something that otherwise should be in the realm of the defense to ask for it to be law applicable to the case, as if they would with a lesser included offense instruction? Because we know that defendants don't have to ask for a lesser included offense instruction. And
True.
if they don't, it doesn't become law applicable to the case.
True, and the trial judge on his own could incorporate a lesser included offense.
Right.
That's absolutely correct.
Okay.
But the law is also clear that the trial court has no duty to sua sponte submit a defensive issue, like an E1.
And there's the crux. Is
Yes.
this a defensive issue? Or
Yes.
is it an element of the offense?
Okay, let me clarify this. This court's prior opinion in Green and Lennox said that it was a element of the offense, okay? So there's two prongs to the state's argument here. The first prong is that if it's an element of the offense, it was left out of this indictment and it was never quashed. That's prong number one. Prong number two is that E1 is also a defensive issue that might reduce a otherwise state jail felony offense to potentially a Class B misdemeanor based on the amount of the forged checks. And so if it's a defensive issue, then the trial court has no sua sponte duty to incorporate a defensive issue that Mr. Lennox never asked for. So either one of these two prongs, the state's right and we win. So that's the two-prong argument that I want to present to the court to answer your question. If it's an element of the offense, it's a defective indictment, and a defect in an indictment has to be raised pre-trial in a motion to quash under Studer, under Teal, under 1.15B of the Code of Criminal Procedure. That was never done here. And it's the state's argument that that has not been preserved. And because it's not been preserved, it went to trial under 3221 subsection D as a state jail forgery of a financial instrument.
Well, I'd say that troubles me because there have been a couple of cases over the last couple of years where it seems the court has, in my view, right, mixed metaphors, right, where the court has said that, no, this isn't a jury charge problem, it's a sentencing problem. Or this isn't a jury charge problem, it's an indictment problem. And that, when the party raising the question is raising a jury charge question. So it seems to me when the question is a jury charge question, shouldn't we treat it like a jury charge question and answer that question? I don't see this, I don't know that is one of the grounds of review that we granted whether the indictment was sufficient? Did we grant a ground of review like that? Because I don't remember that being one of the grounds that we granted.
Well, what the court granted two grounds. Number one was that the Court of Appeals never addressed the preservation issues on remand. It specifically did not follow the directive that this court said in Green and in Lennox, which is, by the way, on page 10 of our brief. We've set forth what this court said in Green. Quote, "We expressly do not decide at this juncture whether and under what circumstances a defendant may raise such a claim pre-trial based on the facts alleged in the indictment, as opposed to only being able to raise such a claim after the facts have been adduced at trial. We similarly do not decide at this time what preservation requirements would apply to such a claim that the defendant is being prosecuted under the wrong statutory subsection," close quote. That's what this court said at page 278 of the opinion. Now, having said that, we drafted our ground of error in a manner that simply asked, on remand, did the Court of Appeals correctly decide whether and under what circumstances any defendant, thus the big picture, any defendant, including the appellant Lennox, might raise a claim that he was being prosecuted under the wrong statutory subsection, i.e. E1. as this court directed in Green, or upon de novo review was error not preserved on this important question of law. That's the ground the court granted on, and that's what I'm trying to say. This is not preserved. E1 is not here.
But that's premised on two default positions you're taking that are different from each other by definition, right? One is
Yes.
that the value ladder was not included anywhere on the face of the indictment,
Yes, sir.
right? But does
Correct.
the indictment, to be sufficient for these purposes, need to cite to subsections and paragraphs, right? I mean,
Right.
the indictment did include the amounts of the checks.
Yes.
Right?
Yes.
So how is it not present in the indictment?
Well, it didn't track E1.
Does it need to track it? Does it have to go E1, E2, E3? I mean, if that were true and there were a Scrivener's error in an indictment that had the wrong paragraph, it said C instead of B,
Yes.
would we have a deficient indictment?
No, because it's not, that's a form defect. That's.
Okay, but why isn't, you included, I think there were copies of the checks.
Yes,
Okay,
yes.
so what's missing? I mean, it's facts, the point of the indictment is to give due process notice to the defendant of what it
Yes.
is he's accused of.
Yes.
That's factual, right?
Yes.
Doesn't need to say, it needs to say against the peace and dignity of the state, if I remember correctly, but it doesn't have to say subparagraph E1-2-3, does it?
No, it does not.
Okay.
But it does have to state something that says what E1 is specifically designed to invoke, which is that it was for goods or services, that could include money. It could have done any number of different things, but it doesn't say that.
Why would the legislature write a law like this? I mean, it's so odd. I mean, normally, you're arguing it's a defensive issue, right?
Yes.
Okay, so normally when the legislature writes a defensive issue, they create it as a defense, and they'll say it's a defense, or they'll put it in an area of the code that where there's other defenses. It's very unusual for them to write a law like this. I think we've said that a couple times, but is it the case that there are no circumstances where someone can commit a forgery without doing so in order to obtain property or services? Or are there circumstances when someone can that are different, so that the legislature might be saying there's a public interest in treating these people more leniently at stake?
Okay. I'm not here to question our legislature. Let me say that first of all. Could they have written it better? Perhaps. Are there factual scenarios where you can forge a certain document and the consequences not be under E1? Yes. But for specific purposes of this very case, we're talking about a financial instrument that was clearly subject to E1 and the value ladder, and it was simply never raised. Not at trial, not at the jury charge conference, not at any time during Mr. LENNOX's trial did this ever come up. So to now come back and say, well, it wasn't preserved. It simply wasn't. And you can't unring that bell. I see I'm out of time, unless I'm happy to continue to address your disagreements with the legislature, even my disagreements with the legislature. The legislature could fix subsection E1, but I don't want to argue this again like I did in 2020 ineffectively.
Well, I don't know about that. It's hard to lose the same issue twice if you're on the opposite sides of it both times.
Exactly. Exactly.
We'll find out. But, okay, you've got 5 minutes, I think, reserved for rebuttal.
Thank you.
Thank you.
May it please the court. Mr. Shell, I'm Troy Hornsby. I'm an attorney in Texarkana. I've been representing Mr. LENNOX from the beginning, about 6 years ago. Based upon the law applicable to this case as laid out by this court and the particular facts of this case, I don't feel the Court of Appeals had any reasonable choice other than what they did. And let me explain what I mean by that. Let me address first the indictment issue. I believe that the indictment, and I've maintained from the beginning, that indictment does allege E1. It does allege the value ladder. Why? This court said, what makes the E1 section, the value ladder, different than the D section? 2 elements: the amount, and that it was for the for property or services, I believe. I can't, property or services. Those are the 2 elements. Okay, do we have those 2 elements here? We do. Not in the wording of the indictment. If we looked at the indictment, I admit, follows D perfectly. But the state put little images of the 3 checks in the indictment. So what do we know from looking at those 3 images? We know there were 3 checks. We know that the amounts were $130, $137, and $150. Exactly. Well, check that. We know the value amounts. They're in the indictment. What was it for property? It was. How do we know? The check is written to Bobby LEANOX, my client. It's for cash. Cash qualifies as property. We know that statutorily, right? So the 2 elements that this court said, you got to meet these elements. If you meet these elements, you now have E1. They're in the indictment. They're in the indictment. So, although, and now you could say, well, but the indictment follows D, and then you have this extra information. True. They're both in there, D and E1. So you go, all right, well, wait, now you've got both in there. What do we do now? Well, we know the statute says that E1 is subject to the value ladder. This court said that it controls. Okay, we got D1 and we've got D and we've got E1, both in the indictment. We know E1 controls. The indictment alleges E1. Move on.
Let me ask you this, though. The statute says that it depends on the facts at trial ultimately showing.
It does, yes.
So why would it have to be in the indictment?
I don't think that it does. No, I don't think that it does. Absolutely not. In fact, this court made that implication in when it wrote about this, that in fact you could allege a Section D violation in the indictment. You go on to trial and, hey, wait, this looks more like E1 based upon the facts. I absolutely agree. You're absolutely correct. So no, I don't think it is. I'm just saying if the challenge is, hey, you should have objected to the indictment, I'm just trying to throw that argument out. I'm saying, wait, we don't have to object to the indictment. There's nothing wrong with the indictment.
But there I guess I'm just thinking there wouldn't have been anything wrong with the indictment even if it hadn't had
I completely agree with you.
under E1.
I completely agree with you. Yes, ma'am. So now we've got to move on to the second thing. All right, well, what do we have here? What is this? Okay. The structure of these charge errors has been addressed by this court for years. We've got a little subsection estoppel. What's estoppel? Well, if I, as the defendant, request an instruction, well, now I can't come back later and start complaining about it. Well, we didn't Mr. LENNOX didn't request an instruction, so estoppel is right out. Forget estoppel. It's not an issue. Okay. And we're going to get to the Almanza part here in a minute. But what does that leave us with? That leaves us with what I call optional or defensive issues. That's where we need to look, right? Is this a defensive issue?
Let me ask you a quick question.
Yes, sir.
Does it make any difference at all that the indictment literally says it's state jail felon? I mean, that's what it describes it as. Does that make any difference?
No, I don't think so because it's alleging both, Your Honor. I think it's alleging both.
So there's no duty to clarify, to object, to point that out?
No, Your Honor, you might have an indictment which charges murder and later, you're looking at lesser included issues, right? I mean, so you say, well, hey, it's alleged murder. You can't have manslaughter. Well, sure you can. Sure you can, right? It's a lesser included. This isn't lesser included. I'm not saying that. But
Right, this isn't a lesser
It
included.
is not, and I'm going to address that.
Okay.
Yes, sir. I'm going to address that. So under optional, I put lesser included instructions. what you're raising there, Your Honor. Defensive instructions, affirmative defenses, these sort of things. These are defensive issues. This court addressed that in Posey v. State. What is a defensive issue? It's something that has a strategic decision. Maybe you want it, maybe you don't. It's optional, right? It is, quote, under Chase v. State, discretionary. Maybe it's in there, maybe it's not. It is not the law applicable to the case, as you were saying. It is not the law applicable to the case. Ergo, it is a forfeitable right. And that makes sense when we understand all those things, right? Hey, well, maybe it has to be in there, maybe it should be in there, maybe it's not. It's not mandatory. You can waive it. And in this court addressed that more particularly in Taylor v. State in 2011. It talked about these things. Does the statute call it a defense? No. Is it a strategic decision? Is it discretionary? Or is it the law applicable to the case? All right. So we've got a framework to work in. So now let's try to apply that here. Here, it is not a defense. How do we know? You said so. You said it's not a defense. You said it's one of 4 offenses. They're under there. You say there's 4 offenses under there. It's a special deal. Why? Why would I say it's special? Because we clearly, the statute says that D1 is subject to, and it controls. Okay, so what is that? I think it starts to smell like lesser included, but something more, something bigger, something stronger. Why? Well, because lesser included is discretionary, right? But this isn't discretionary. The legislature said so, you said so. It controls. That sounds like law of the case to me. Law applicable to the case, I'm sorry to say that. Law applicable to the case.
Can you help me understand something?
Yes, sir.
Because we're supposed to read the entire statute. The entire statute is supposed to be given effect.
Yes, sir.
But I'm curious because people are making you're suggesting that cash is property.
I am.
Or services, I guess, but it's cash.
Cash,
So
cash.
it's, if that's true, then when is a forgery not for property or services?
Yeah. We had the exact same question
Yeah.
at the Court of Appeals, and to be honest with you, I can't answer that. I don't know.
I mean, why would the legislature say, that there's the defendant always has the value ladder? I mean, they're essentially, that argument leads ultimately, it seems,
Why is it?
to the conclusion that this offense is never a state jail felony. And I think the legislature said, though, it is in some circumstances, and this is what it's very difficult to try to figure out is how do you give effect to that language that it can be a felony if cash is property or services, is included in that?
Well, I'm not willing to give up on the argument that it could be for something else. I suppose it could be for something else, some sort of influence or something along those lines. I'm not sure how that could work. I'd have to think that through. But to answer your question more directly, it's not in a vacuum because you've got the value amounts too, right? I mean, the value amount's restricted, right? We're only talking about little checks here, right? $750. Up to $750, right? The other, if it's over $750, regardless of what it's for, or it's for goods and services, but $751, well, it's going to fall under D.
Well, so what public interest then, let me ask you this, is there a public interest that's served by saying someone who does this, who commits a forgery for something other than property or services is really, really bad?
Yeah.
And someone who does it for property or services, yeah, we just understand. Some humans do bad things sometimes. They steal bread because they're hungry. They might steal a car because they think that it's important to get across town for some reason. And in those circumstances, we don't want to punish them too severely. But if they're doing it for something else other than property or services, what is that else thing? That seems to me the way this statute suggests by its plain language. And I'm wondering, is there some public interest at stake that they're trying to protect here?
Judge, I understand your question. I'm sorry, I don't have an answer for you. I'm sorry, that's the honest truth.
Well, I have a different question.
Yes, sir.
Again, I have to go back to this. I'm looking at the indictment, okay?
Sir.
And it says punished as second-degree felony. Now,
Objection.
if this is an E1 misdemeanor indictment, is there any way that these prior felonies can aggravate this or enhance this to a second-degree felony? Not that I'm aware of. Is there one that I'm missing?
No, sir.
So if this is an E1 misdemeanor indictment,
Correct.
that language, punished as a second degree, even if
Yes.
you get past the state jail felony piece, that language, punished as a second degree, that is a clear indication to defense counsel that the state is moving forward as state jail felonies and that he must make an objection so his client doesn't get hammered with a second degree felony, which is what happened here, is it not?
I agree with the first part of your question, and you had me all the way up.
Then where do you deviate on the second?
It alleges both. If it didn't allege both, if it just went that far, and you didn't include the check amounts, I'd say, you're right, looks like D, no choice, we're stuck under D, gotta raise our hand. But it goes on, and it alleges, it has the check, ergo it alleges D and E1, both.
But on these check amounts, there's no way to get to a felony.
I agree with you.
Okay, so how is it alleging if you're saying the fact that these images of these checks with these amounts are in the indictment alleges both a D felony and an E1 misdemeanor?
Yes, sir.
But if these amounts, under any interpretation of the statute, cannot be a felony, then they cannot be D. How do we get past that?
Well, those facts may or may not end up being true at trial. I mean, you could allege one thing and it's not true or it's not proved at trial.
But what's alleged here is D, a felony, a state jail felony enhanced to punishment as a second degree felony.
I contend it's both.
Okay.
I contend it's both. I don't know how to, I'm sorry, I'm not trying to be argumentative.
No, that's the point. That's what we're here for.
I completely agree that it does follow, and in a perfect world, should an objection have been made? Yeah, that would have been great. It would have been great. It wasn't. But my contention has to be that just because you allege something doesn't necessarily mean it be proved at trial. It could go to trial, and we know that, that the statute says if it is proven at trial, E1, then it's E1. Well, it might have been D. It might have been D at the trial. Here it wasn't. It was proved to be E1 with the check amounts and the purpose at that time.
I have a question for you. What if you assume it was only D1? Isn't this really a sufficiency question?
I'm sorry, I'm not following.
If you assume it's only D1 in the indictment, isn't it really a sufficiency question?
Well, that becomes a little difficult because the state's going to argue it's lesser included, and if you qualify for, if you offer evidence of that, that would be their argument. If you offer evidence of that, well, then you've met D and E1. That would be their argument. My contention, my counter response to that, to go down the road, is that it's not lesser included. Why? Again, the argument, it is subject to or controlled by. So my contention is not lesser included. If it's lesser included, then it becomes a little bit more problematic, right?
Right.
I don't know how to answer that any further than that. Having given all that, back on track. We know it's not a estoppel. Cast that out. My argument is it's not a defensive issue. Cast that out. If we've casted that out, what are we left with? We're left with the structure of jury charge error as established by Almanza, which is, was there an error? Was there harm? If it was objected to. Or, if it was objected to, was there an error and was it egregious error?
Wait a minute. He was convicted of a felony, aggravated to a second degree felony on what would arguably be 3 Class B misdemeanors. How is that not egregious error?
I completely agree, and that's what the Court of Appeals said.
Okay.
I completely agree.
But you said that both apply, D and E. So if both apply, how is there a jury charge error? What would be the jury charge error if you're saying the indictment alleged both?
Yes,
If I'm following your argument correctly.
you're correct, and I agree with that. But again, we're going back to, hey, okay, you've gone down the road. Indictment, D, E1. Evidence, D, E1. Charge, what do we do? Well, we know what we do because the statute says that D is subject to E1, and we know that this court says E1 controls. It's not optional. It's not optional at that point. If the indictment and the evidence show both, and we get to the end and we're at the charge error, or we're at the charge conference, then the court has one choice. The court must submit E1. because it controls, has no choice. It's not a lesser included. It's not a strategy decision. It's not elective. It's not discretionary. Must be done. It is the law applicable to the case. That's my contention. Which is why, again, circling around, that's why I say it's not a defensive issue.
Well, let me go back to you there.
Yes,
with
sir.
that. It's not a defensive issue because it's subject to, and it's not discretionary.
Yes.
But normally, with respect to a lesser included offense, there's a separate step for the trial court to make about whether it's possible that he could be guilty of the lesser but not
Yes.
the greater. Is it possible that the legislature, by making it subject to, cut off that much of the discretionary nature of the lesser included and still left it obligatory for you to raise it before the trial court in order for the issue to be preserved for purposes of omission from a jury charge?
Is that possible? I don't know. I'm only making the argument with regard to this particular case. And I'm saying in this particular case that proof, that the proof was the three checks, 130, 137, 150, and the purpose, cash, that if that's true, if that's objectively true and it's not contested, as it wasn't here, that's objective, in that situation, it's not lesser included because it can't be both. That's my argument. Now, could it be in other situations?
It's a little hard to criticize a trial court for not reconciling itself to a decision that hadn't been handed down yet.
Completely agree.
Okay.
Completely agree with that, Your Honor.
We do have the power under, I believe it's 78F. Well, we'll address that. Maybe I'll address that later, but applying this decision retroactively to this case is what's causing the
I
challenge, right?
completely agree with that, Your Honor, and I think I think one thing we can agree to is that we have all stumbled through this from the beginning.
Welcome.
And it has been a difficult process.
And I appreciate you going through it with us.
More credit to the state, the state was the first one to really fully understand the problem and to bring it our attention, correctly so. And we've been wrestling in that mud since then, and I think it's remarkably difficult. And I completely agree with the retroactive application because that has application with regard to ineffective assistance of counsel or what the judge did. And when we're looking back 6 years, that strikes me as bonkers, just bonkers. But I hadn't intended to address that with regard to.
Let me maybe go in a little different direction, which
Yes,
is,
sir.
because it seems to me you've taken things and you've pushed them aside, right? And you've taken defensive instruction and put it aside, but there's also, Presiding Judge Schenk mentioned lesser included offenses.
Lesser
And
included.
it seems to me that when it comes to Almanza, right, that we've treated those two categories, defensive instructions and lesser included offense instructions, differently. And the reason we've treated them differently than typical errors in a charge is because we've said that a defendant has a duty to bring those things up, because he can choose to either bring them up or not. It could be a strategic reason
I
why he
agree.
might not want to do that.
I agree with that.
Right? So, is there any, what would be your argument that this is not a lesser included offense, keeping in mind that there are some specific legislative definitions of lesser included offenses under 3709? And so, I mean, a lot of people think of lesser included offenses and they think, well, if it has one less element,
Right.
then it's a lesser included offense.
Right.
But there really are more definitions of lesser included offenses than
Yeah.
that, right?
Agreed.
And so, have you eliminated the possibility that this E1 crime could be a lesser included offense to the one that was actually charged?
Could it be theoretically? Yes, yes. What's my argument that it's not? My only argument can be that the legislature specifically said something special, and it said it is subject to.
Yeah.
That's all I've got.
Why doesn't that mean then that if it's a lesser included offense under that other instruction, then it's not this?
Well, the
It's
Court of
not
Appeals-
D, if it's E, that's what they're saying. If it's E1, it's not D.
Yes.
So
Yes.
doesn't that fit when you're talking about possible lesser included offense? The legislature may be going after, saying that perhaps
Yeah.
there's a public interest in making sure that when somebody is only trying to get property or services, then we don't want to punish them as harshly. So what's the category when they're not trying to get property or services, when they ought to be punished more harshly and not more leniently? Do you see what I'm thinking about here? Or,
Yeah, my
okay.
time is up, so to respond, if I could. Yeah. I think that's got to tie in with the amounts, that those two together come together to make that differentiation, not just the purpose, but the amounts, that those tie together to make it. But to make the point, the Court of Appeals addressed this the first time and said, well, I think here's my conclusions. Boom, 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 boom. This court came back and said, we agree with 1 and 2, we don't agree with the rest, and you addressed it. Well, what was 1 and 2 that you agreed with? I took that from the Court of Appeals to mean, and from this court's opinion, that it controls, and that you were saying something special. I thought, maybe I'm wrong, that you were saying that when those two overlap, that it's not lesser included, there's no question, no discretion, E1 applies. That's what I took it as. I may be wrong, that's what I understood it to be. I'm over my time, I apologize, I appreciate the court's attention.
Thank you very much. We'll now hear rebuttal.
All right, Mr. Shell, I'm going to ambush you before you start.
This is a great way for me to start.
So you mentioned, well, the defendant didn't file a motion to quash, didn't complain pre-trial. Like, what's the defendant supposed to complain about? Like, I'm putting my trial judge hat on, so I'm sitting in docket, and they come up and they say, well, Judge, we have a motion to quash. What's it based on? He's charging me the state charged me under the wrong section.
Yes, sir.
I would look at him like, okay, what do you want me to do about it? Does the indictment allege a complete offense? Well, yeah, but they're charging me under the wrong section. Like, what is the trial judge supposed to do? The trial judge just go, well, I guess we'll see what happens at trial, right?
Well, I think the trial court judge first takes a look at the indictment, and then he or she then hears the arguments of counsel.
But what
then
would the
this-
argument be? But the argument would be necessarily from the defense would be, no, my guy was trying to get goods and services. So he's being charged in the wrong section. And the state would say, I'm sorry, is anyone sitting in the witness stand right now? How do we know that? All I know is I have an indictment with a complete offense. Like, what would you want the trial court to do?
Okay, here's how I'm going to address your question. First of all, the indictment comes out from the grand jury. District clerk gives a copy of the indictment to the state, gives a copy of the indictment to the defense attorney. Shortly thereafter, 39.14, Michael Moore Discovery Act, requires the state, upon reasonable request, to then provide discovery to the defense attorney. The defense attorney then takes the time to look at that discovery and determine what the evidence truly is. What does the state truly have in its possession that proves that whatever is alleged to be the forgery, which is a writing, by the way, that's the key to any forgery, the writing. Then the defense is in a position to say, this evidence that you have provided me as defense counsel proves that this is subject to either D, E, or E1. And Judge, this is our argument. Our argument is, based on what we've seen in discovery, this is an offense under E1, and they haven't charged it this way. Therefore, the defense's motion to quash should be granted.
What about your compatriot's argument that it was charged under E1?
Well, I don't think it was. We're going to have to disagree on that. Right? It's a 6-year-old case. We've disagreed before, and it's okay. But if you look at this indictment, to Judge Finley's point, says state jail felony. It doesn't say state jail felony 32.21E1. It doesn't say that. It doesn't say D either. But
Counsel?
this court said in Green, okay, Green was the companion case to LENNOX. Green went up, and the difference between Green and LENNOX is Green involved a $20 forged bill. that under E used to be a third-degree felony. You don't forge our money.
Counsel,
Yes.
I was wondering, can you commit forgery without actually uttering the forged instrument?
You can possess it.
Right.
Yes.
So why is it the conduct engaged to obtain property or services isn't a reference to uttering the document rather than merely possessing it?
Well, I think that becomes then a question of manner and means. Is it uttered? Is it passed?
But that might suggest two different offenses.
It could, but it's still within the global framework of a forgery.
Counsel?
Yes.
Should we give any significance to the fact that this is an indictment and not an information? I understand you can use an indictment for a misdemeanor, but
Sure.
if this is a misdemeanor complete, should we give any significance to the fact that it's an indictment, generally used for felonies, as opposed to an information?
Correct. Well, it's an indictment, but it's not an information. If it was an information under E1, then it wouldn't have been in the 6th District Court
That's
to
my
begin
point
with.
exactly. If this issue is, hey, this is actually a misdemeanor, not a felony,
Yes,
that
sir.
would deprive this court of jurisdiction.
Yes,
Is that not something counsel would be expected to bring up before you went to trial?
absolutely it
Should we
would
give
have
any
been.
significance to that?
It absolutely has significance, and that's part of my point here. Part of my point is that, look, this was alleged as a state jail felony. He contends it's a misdemeanor. If it's a misdemeanor, then you object, you move to quash, and it goes to a county court at law in Lamar County. But that's not what happened here. That's my whole point. There was no motion to quash this indictment.
So is there any significance to defense counsel proceeding in the district court where he would know it would have to rise to the level of a felony to be? Is there any significance to that or no?
He would have to go forward in the district court, and then at some point in time, bring up, as the evidence developed during the trial, that E1 is in play. And then E1 requires this to be done in a different manner. But for purposes of this, and this is where the state's asking for very specific relief, to avoid going retroactively back. Affirm the trial court's conviction, clarify what E1 means. Is it a lesser, is it a defensive issue? What is it? Don't use this case as a test case. Affirm what the trial court did. Say that this was never preserved under Marin.
Couldn't we have done that the first time? But we didn't, right? The reason I ask, I've asked this question earlier, I'm still used to the Court of Appeals companion to what is Rule 78 for us. But that has should. Ours do not have should. We basically can enter any order under Rule 78 that we think is necessary to get the case justly and efficiently decided.
Yes, sir.
We're a little late in this one, but there should not be a third proceeding in the Court of Appeals. Would you agree with that?
I agree. That's why this is a de novo review, and that's why we framed it as a de novo review, so that this court could make a final call. We're asking this court to make the final call and affirm the trial court's final judgment of conviction and reverse the judgment and opinion of the Court of Appeals. I see that I am way over my time.
Well, thank you. Thank you both.
Thank you.
All right, I think we'll proceed to the next argument. This case will be taken under submission. Our next case on the docket today is John Richard DUDAS versus State of Texas. It's PD 0221-25. As counsel are approaching, I'll remind you if you would be so kind to identify yourself as you approach the podium. And we're hearing first from counsel for Mr. DUDAS.
Yes, may it please the court. Counsel? I'm John Bennett. I'm representing Mr. DUDAS. Putting words in the mouth of people who are perfectly capable of speaking for themselves is at least presumptuous and might be dangerous. And unless ambiguous or impossible or unconstitutional, the words the legislature uses to craft statutes are paramount. This is particularly so where a statute's text says it will only be precluded with plainly expressed legislative intent. The legislature has plainly expressed legislative intent on nearby statutes. 9.41 of the Penal Code deals with defense of one's own property. 9.43 deals with protection of other people's property. 9.44 deals with devices to protect one's property, and it says openly, this provision only applies if 9.41 or 9.43 is met. But the forerunner of this court decision in Bowen at the Court of Appeals, the court looked at 3 different statutes, necessity, non-deadly force, and resisting arrest. All of them enacted or amended then at different times by at least 2 different legislatures, tried to harmonize them, and then came up with a plain legislative intent from all this. This court sensibly said, no, that's not the way it works. Excuse me. That's not the way it works. You are entitled to all defenses that the evidence meets. Then we let the jury sort it out. That's the jury's role and prerogative. The only way such mental gymnastics as the Court of Appeals in Bowen did, to me, seems to say something can be plain but implicit. How that is done escapes me. But the court, as I say, reversed Bowen.
Doesn't the defense of self-defense include the word necessity or necessary in it?
It could be read that way, yes, Your Honor, and the Court of Appeals did.
What did your client lose from the perspective of a juror who is inclined to accept that he acted out of necessity to protect himself from the absence of a necessity, separate necessity question?
He lost all the less burdensome conditions that are attached to necessity. Necessity is much easier to meet than deadly force in defense of person. And a court, under this logic,
On the facts of this case?
yes, sir. Under this logic, a Court of Appeals could conceivably say that if you don't get a necessity defense, you don't get a defense of deadly force in defense of person thing. That would be for the defendant. It would hamper the state. But in this case, it hampers the defendant and he's for the state. As Bowen said, neither one should be done. We give them all defenses and the jury sorts it out.
What do you make of the distinction between necessity and these other defensive instructions like self-defense and deadly force self-defense, where the necessity statute justifies conduct and these other self-defense or deadly force self-defense justify the use of force, which it seems to me is a particular kind of conduct?
Indeed, Your Honor.
What do you make about that distinction? I mean, doesn't it suggest that the legislature wants there to be a necessity defense for conduct generally, but if that conduct is the use of force, do you see it as these other provisions providing more specific provisions that are required to be met in order to justify that use of force?
Absolutely, Your Honor. But
Okay.
I don't see a plain legislative intent to preclude necessity, which necessity says has to be there.
Okay, I mean, we still would have to analyze that under the category of what do the facts of this case show, right? Because we don't know what the facts are gonna show until you try the case, right?
Of course, Your Honor.
So, but it seems to me that you've got a very broad justification for just about any conduct that might occur, and then the legislature speaks specifically to the use of force, and they say, if you're gonna try to justify use of force, don't you have to meet all these provisions that the use of force justifications require?
That is proper interpretation of them, yes, Your
Okay,
Honor.
thanks.
But the legislature said in 922 it's only precluded with plain legislative intent, which I don't see there at all. And particularly in the offense in question, there is no such language. There was no such language in 9.31, non-deadly self-defense and necessity defense. But this court said do both of them.
What conduct is your client attempting to justify?
That he was pulled from a car by a heavier,
Well, surely he's not charged with a crime for having been pulled from a car.
no, he's charged with a crime because the only thing he had to defend himself was a pocket knife, and he produced that and slashed or stabbed wildly at this assailant.
So is slashing or stabbing with a knife the use of force?
It's either the use of force or the use of defense. Yes, Your Honor.
Well, that's what, I mean, he has, these defenses say they're trying to justify the use of force. I mean,
Yes, indeed.
So if it's trying to justify the use of force, why shouldn't we defer to the category of statutory defenses that attempts to justify the use of force?
Because there's no plain legislative intent that is plainly expressed. It may be implicit, but that's not good enough.
Well, no,
Necessity says. I'm sorry.
Sorry, Judge Urey's point that if the legislature narrowed the focus of otherwise overlapping potential conduct, conduct, one involving force, and then specifically within that, deadly force as a separate kind, isn't that a totally different category? Isn't it, the legislature carved off into separate silos three increasingly more narrowly available defensive questions to put to a jury depending on which of the three may be implicated?
Yes, sir.
Potentially more than one, I guess, is your point.
I'm sorry,
Potentially more than one, I suppose, is your point.
potentially more than one legislature, yes.
Well, and more than one.
So whether they are inconsistent or not, as this court said in Bowen, you get all of them. The jury has to sort it out. Then in Chase, which was based on unpublished cases before that, the Court of Appeals did the same sort of analysis and reached the same sort of conclusion that this court explicitly disapproved in Bowen. The Chase court said, and I quote, "Where the jury received an instruction for one confession and avoidance defense, but not another at trial, a reviewing court must determine whether the defenses overlapped, such that the self-defense instruction precluded harm from the absence of a necessity instruction," unquote. That's what the Bowen court said. You can't do that. The legislature has spoken, or perhaps two legislatures have spoken, but that's what the legislature enacted. If Chase, the state's brief in this case now takes a completely different tack. It seems to be abandoning the questionable logic of Chase. The state's brief says, well, all lives are equally valuable. That's an interesting proposition. Whether the legislature had it in mind when it enacted the necessity defense, nobody can tell, but it's certainly a contested sort of proposition. Does it mesh with human nature? Not without qualifications. If a drunken driver is there, you have a chance to shoot the drunken driver in the head. If you don't, he's going to mow down a child. Can anyone honestly say that that drunken driver's life is as valuable as the child's? I can't. Perhaps you can. I can't. But Texas law also denies this proposition, goes against this proposition. Say the transient here robbed and killed someone. If punishment conditions are right, the state says it has the right to take the man's life. It's not as important as anybody else. Texas law defies this proposition. Several philosophers mentioned in my brief have also defied the proposition, but that's neither here nor there. Did the transient here...
Excuse me, so how do you weigh the harm? I mean, I'm empathetic, so, you know, in this situation, it's a difficult situation. So how do you get to the necessity, and how do you weigh the harm? Is there any other way to weigh the harm versus one life against another life? Do you have an argument for that?
Yes, Your Honor. The necessity defense makes it much less burdensome for the defendant. And so...
I understand, so, but how do you weigh the harm in part two, based on the facts of this case, the second element of necessity? How do you do that?
I'm honestly not sure, Your Honor.
Is there, I mean, is there really a suggestion that the jury would find against the defendant on his self-defense argument, but then, but he did act with necessity? Is
Juries
that
have
really
done stranger things, Your Honor.
the fact that you're saying it's a strange thing is my point?
Excuse me?
Is the fact that you're equating it with jurors who've done stranger things is my point.
Yeah.
I'm not seeing what else there would be that the jury wasn't able to consider through the self-defense instruction.
True, it could consider.
I mean,
the personal
hypothetically or
characteristics of each one.
theoretically, it does lower certain burdens and everything, but realistically, under the facts of this case, how would that be, how can you say the defendant was harmed by not getting the necessity instruction when he was given the self-defense instruction?
He was given a deadly self-defense instruction.
Mm-hmm.
He wasn't given the necessity instruction. The necessity instruction would have allowed him to say, well,
That's what I'm getting at.
allowed the jury to say, well, we don't think he has perfect self-defense. We have the doctrine on the other jurisdictions, imperfect self-defense, but necessity allows him to do it anyway. I think that's the only answer I can come up with.
Okay.
How does necessity allow him to do that? I think Judge Noel and I might be asking the same question. That's my question. I'm interested, how do you make that argument that necessity based on these facts is a solid defense?
Based on the imperfect self-defense.
But but applied to the facts, how do you get there? Like, if you look at these facts, was there a necessity under the facts of this case?
A necessity to save his life. And to use whatever force is necessary, even if self-defense, even if deadly force in defense of person is not met. He was pulled from a car onto the asphalt on a very dark night, late at night, by somebody who walked towards him and said, I'm going to kill you. The necessity of acting as he did is for whatever reason. Whatever reason the jury comes up with, that's what the point is.
Jurors might have wanted to protect the dogs, right?
Beg pardon?
They might have wanted to protect the dogs. He was tormenting the dogs too, right?
I suppose so.
But other than that,
Other than that, yes, you're right.
that's, I think the challenge in this case is, you had a self-defense argument, it's a more narrowly available argument, right? I mean, you have to be in defense of yourself or someone else reasonably.
Yes,
and
indeed,
you got
Your Honor.
that.
Yes, indeed.
And I think that's what we're all struggling with is what difference is potentially made, and is the legislature by separately stating these things and narrowing their application potentially being explicit about the possibility that one will be available and the other may not be.
The difference, I mean, I'm sorry, the point, I think, is that necessity is sort of so much broader, that it can apply in situations where deadly force in defense of person does not apply.
Well, I need to just, okay. The way I'm looking at this is we have one set, necessity. Within that set, we have a smaller set, self-defense, okay? A specialized category of necessity that has certain requirements. And within that set, we have self-defense using deadly force.
Yes.
Okay? Anything that is self-defense using deadly force that obtains there necessarily obtains for self-defense, and anything that obtains for self-defense necessarily obtains for necessity. Here, the legislature has specifically given enumerated instances in which self-defense using deadly force can be used, and excluded all others. So if that's the way it is, necessity, subset, self-defense, deadly force, and the legislature specifically said self-defense deadly force can only be used in these circumstances and no others, how does that not indicate that the legislature is specifically saying necessity is not available when there's a self-defense deadly force?
Because it retained both provisions, and the self-defense and deadly self-defense were amended after Bowen and did not remove necessity from deadly force and self-defense. You get both, because deadly force is much harder to meet than his necessity defense. And therefore, he was entitled to both. Whatever the jury might have thought. Juries are not predictable, let's put it that way.
Doesn't the very existence of a separate provision that might justify the use of force as opposed to other types of conduct suggest a plain legislative intent that the use of force type situations should be treated differently than the broader category of conduct?
It might well, Your Honor, but that's not a plainly expressed legislative intent, which the legislature took pains to say in the necessity defense. Thank you all very much.
Thank you. We look forward to hearing your rebuttal. We'll hear from counsel from the state.
May it please the court, my name is Emily Johnson-Liu on behalf of the state. This court doesn't have to address the legislative purpose in the plain language of that. Instead, this court could decide on the second element of necessity, that wasn't met here, and in most murder cases it is not, because the second element is the balancing of harms. Harms on the one sense of what was the harm that his conduct was trying to prevent versus what is the harm that the murder statute tries to prevent. And you always have in a murder case, you always have on this side of the scale, the life of a person. So the defense here, at least his position in the briefing, is that he was attempting to get his conduct is trying to avert injury to himself. Perhaps there's an argument from the evidence that he's trying to avert his own death. But mere injury or death of one person cannot clearly outweigh the death of another person. That's going to be true
Even if it's your own death.
even if it's your own death. And that, I think, is because the legislature makes this a justification and not an excuse. The closest cousin for necessity is duress, which the Texas legislature puts into general defenses. But they put this defense in justification. And the difference is, justification is you actually made the right choice between socially desirable outcomes. You chose the thing that objectively you made society better.
Well, self-defense is you're entitled based on preservation of yourself, but the necessity is, no, we're viewing this in the context of the greater good for society as a whole.
Correct. So it is a sort of cut and dried comparison of harms in a way that self-defense is not. Self-defense is more structured.
By that construction, necessity would never be defense in a murder case, right?
No, it could be.
When?
If you were trying to defend more lives than just your own, then in that case, if you end up, killing
The
a
classic
person.
thought experiment of the railroad car going down one track where it would kill one person versus going
five.
down the other
Five.
track where it would kill 5.
Correct. So you end up killing one person, but you have saved the lives of 5 other robust children.
There's such a thing as using force in defense of others, right?
Yes, that's right.
What's the difference?
Well, but in that scenario, though, it's unlawful. You're protecting against somebody's unlawful use of force, whereas in the trolley example, maybe not, right? It might be, the person might not be acting unlawfully, but you kill them anyway, right?
Yes, necessity is the broader defense. It assumes there can even be an innocent person, and you take the life of an innocent person, or you cause the death of an innocent person, and necessity still allows that.
Seems impossibly hard then, if that's your distinction, it's impossibly hard for judges, I think, to sort of come in and decide what lives are more valuable than other lives. And, is the life of a child more valuable than the life of 2, nearly deceased in age, right? Older people. I mean, you have to make these value judgments that you're pushing on judges to make about, like, which good is a better good.
That gets back to the question I asked earlier about when would in a murder case, necessity be available, but self-defense would not. You can use force in defense of others, including deadly force, right?
That's
Didn't the
right.
legislature already deal with that?
Yes.
Okay, so when would I be able to switch the train rail to mow down the orphanage as opposed to the prison? Or other way around, and not have self-defense be available? When in a murder case would necessity be available, but self-defense or defense of others would not be?
Think about what you're justifying. Sorry to interject in this question.
And by extension, what factors would that judge look at? Sex, age, race, employment status, contribution to the community?
No, I think if you go under, like, our formulation in Texas is from Model Penal Code formulation. And there it really is just a weighing of abstract harms, life versus, like a numbers game. How many do you have on one side versus the other? And I think most necessity cases never reach trial because they are the understandable situations when prosecutors don't bring them. Where there's a fact issue or where you have a prosecutor that has brought a case, necessity will be there in a situation.
I'm not sure that you need this distinction. I mean, but let me just ask this question. I haven't heard either of you address this. What is the proper standard of review here? I mean, we have a trial judge having to make the decision of how many defenses to include that are potentially overlapping, and whether there's a clear legislative purpose or not. What's the proper standard? Are we talking abuse of discretion, de novo? I mean, because it's a little hard on the trial judge to have to make this determination and just say, oh, you got it wrong, there's no clear legislative purpose, try the case over again.
I think because whether there's a clear legislative purpose, because that's a statutory interpretation question, I think that's a de novo issue for this court.
Right, but your argument is a little different from that, right? You're saying we only have to get there. So
right.
What's the standard of review for your argument?
For my argument, I think it's there as a matter of law. I don't think these facts and most murder cases do not present a case that can go to a jury on this issue.
Well, that's why I asked the question I did of you earlier. But so as a question of matter of law, it would have been error for the judge to give this necessity defense. Okay.
So in a one-on-one situation where somebody's using deadly force in self-defense,
Okay.
your position is necessity could never be given. Nobody else involved, just
No one else
two
involved,
actors?
correct.
Okay.
That's just going to be, in a murder case, necessity is not precluded because you could have more people you're trying to save. But in your average murder case, necessity is not available because that balance is so off, clearly outweigh, and it's a numbers game.
And if there's more than one individual involved, but one of those individuals is using some sort of deadly force against the defendant, is he entitled to use deadly force to protect others?
Under the law of self-defense, yes.
Under necessity?
Under necessity, necessity doesn't have room for that, doesn't provide for the unlawfulness. Necessity is there even for the innocent actor that you end up taking the life of. And so it doesn't provide for unjustified unlawfulness. It's not built into the framework. The only way that the defense is trying to bring that in is essentially by repeating elements or replicating elements of self-defense, but trying to make it easier or
But in the
lower
situation where a defendant is with a group of people and he's the subject of somebody shooting him or using deadly force, and he's protecting himself and others, can you get both defenses at that time?
Yes, I think if there are two separate reasons why, two separate defenses, you can absolutely get both of them. That's going to be really rare.
Right.
Bowen was a situation, I think, that raised
That's
that.
why I asked that question. How does the trial judge determine whether he or she is sitting in that situation, and they're subject to de novo review if they get that wrong? It seems to me your answer is yes.
So the trial judge is just trying to see, are there two distinct defenses here? Necessity and self-defense.
You have to make that decision, right? I mean, if you don't have 8 other colleagues or law clerks
Right.
or staff there with you.
Right.
I mean,
Yes, so I think there is, and trial judge has heard the evidence. So yeah, I think that probably does go more towards an abuse of discretion standard in determining, does this evidence sort of meet both? But there need to be two separate things.
Why isn't this case decidable on the fact that you've got different kinds of conduct at issue, right? You've got conduct generally, and then the legislature went on to say, but if that conduct happens to be the use of force, there's all these conditions, right?
Yes.
And so why isn't that a plain expression of legislative purpose to do something different than necessity when the use of force is involved? If that's what you're trying to justify, as opposed to like getting in a car while drunk to move it off the road, right? That's not the use of force,
Right.
that's something else.
Right.
That's a category that we can easily make a distinction between. Are you trying to justify using force? Okay, well then we're gonna go and look at these other provisions that deal with that. But if you're trying to justify some other kind of conduct other than force, we'll look at necessity then.
Yeah, but I only hesitate about that because maybe there are some, like, the use of force, like the mountaineer examples for necessity. Is that a use of force when you cut the rope? Like, I would, we would want to have the person be able to have necessity in that situation, the 2 lives for one, the, tethered mountaineers.
He has self-defense there too, though, right?
Well, no.
You may, the other person is not acting unlawfully against you, so you still have to have, but, okay, even if you don't have the legislative purpose to exclude, I think there is just a plain old-fashioned statutory interpretation basis to say the legislature doesn't intend for you to completely get rid of some of these qualifications on self-defense, that we have normal statutory interpretation canons in pari materia. This is a whole system meant to work together. Self-defense is over here. Necessity is over here as a gap filler. Surplusage, right? We don't mean for you to be able to obviate all of these restrictions, like the use of deadly force against you is required before you use deadly force. And the general specific canon too, like necessity is more general, deadly force, self-defense. Those are all like general principles of statutory interpretation that I think this court could say, how do we interpret necessity and self-defense? And to the extent that there's a conflict, we're not gonna let you have necessity that's really self-defense light. We're not gonna allow you to do that. But that doesn't mean that we're in the same case. You have 2 separate defenses, necessity and self-defense, that you can't get them. And that's more, I think, the sort of legislative purpose to exclude the defense in the same case. That Bowen is saying that doesn't
Even if there's a
exist.
possibility for death to occur to someone other than the defendant, isn't Judge Urey's question still on point, though? I mean, because the legislature, by having different silos to capture each of these distinct scenarios, still leaves a place for the jury and the defendant to say, excuse my conduct, justify my conduct. But the trial judge trying to choose among them or to include multiple ones has got to make a judgment call there in a moment, right?
Trial judge does, but the trial judge is making these decisions all the time. And I think where, in this case, where you have, in the charge conference, the one party saying, it sounds like these are just replicating, or this makes self-defense redundant to offer that. At that point, yeah, defense counsel can step in and say, here is how it's separate. Here is how our defense is not asking for the use, we're not just justifying the use of force to repel the attack by another. Here's how we're offering something different, like in Bowen. So Bowen is an example where, as the majority understood the facts of that case, it's resisting arrest, and Bowen has handcuffed behind her back, and the officer is pulling up her arms to pick her up. And she says, I am not kicking to repel the officer's unlawful or excessive use of force. I am kicking to regain my balance, to get my footing back, to prevent my arms from being popped out of the cert.
Does the jury have to believe that?
No,
Just because
absolutely
she
not.
said it? I mean, they
Oh,
could think she's kicking because she wants to kick the officer, right? So the jury could believe that she's using force against the officer.
Absolutely, but the question for the judge is, do we submit that issue too? Do we submit necessity too? Is there at least a path that this is something separate and distinct from self-defense? Bowen arguably says yes. Okay, a more extreme example. The jealous, accident-prone mountaineer. So you have two mountaineers. They're tethered to one another, okay? And one of them slips, right? Accident-prone, and he slips. He's tethered to the other one. The other one has is in that necessity situation. Gotta cut the rope or 2 people die, okay? So the one who slips, though, he's jealous, and he says, I've always hated you, guy who's clinging onto the side of the mountain, because you're a better climber than me. And he pulls out a gun, okay? At that point, you have both self-defense, deadly force, self-defense, to cut the rope, and necessity, okay? But those are 2 separate things, and they don't intrude or cross out some of the elements of the other.
But is that, so, isn't that, at least the situation with the knife, right?
Yep.
When you cut a rope, are you engaged in conduct that constitutes the use of force against another? Or are you just engaging in some kind of conduct other than the use of force against another?
Well, conduct has a legal definition.
It does.
It's not just behavior.
It's not just behavior.
It's an act or
It's-
omission, and it's accompanying mental
Mental
state.
state,
So it
right.
really refers to a crime, doesn't it?
Yes.
Commission of a crime.
I don't know why the legislature makes necessity different. It does. And maybe that helps us. But it does seem to be saying, yes, committing this offense is justified if. I think that's a reasonable reading. So
So in the gun situation, is it just self-defense or necessity or both?
it's both. You have to
Okay.
submit both in that. And I think judge, yeah, if he's not sure, then turn to the defense counsel and say, articulate how these things are separate for me. And that wasn't done here because there isn't anything else. The only thing he's offering is, I thought Fisher is coming at me. I either fear for injury to myself or I fear death. That is only deadly force self-defense. And I think you don't have to decide it under the 3rd prong. Just as a matter of ordinary statutory interpretation, you can say the legislature does not intend to conflict the 2. That Bowen says, where there are 2 separate things, give both things. But you don't have to cancel parts of the other one. Unless there is any other questions.
It would appear not. I thank you. We look forward to your rebuttal, sir.
Thank you, Your Honor. May it please the court, to answer the question raised earlier about the harm in this case of not having a necessity instruction. At trial, the state said that the chain that was found in the parking lot was not really a deadly weapon. I said in my reply brief that it was a watch chain. It's actually a wallet chain. But the state made a big deal about this is not a deadly weapon. So based on that, the jury could well have concluded, well, 9.32, deadly force in defense of person does not apply. But Mr. DUDAS acted reasonably in the circumstances, so necessity would have applied even if deadly force in defense of person did not.
Counsel, let me ask you this.
Yes,
How
sir.
do we avoid a necessity defense and under these circumstances from devolving into, maybe what somebody might refer to as the informal common law of he needed killing? Like, how do we avoid, because if necessity is available in a wider group of cases, I can see a scenario where a defense lawyer basically trawls through the deceased person's life and basically argues, look, this guy was nothing, a nobody, he was a terrible person. So really, society's better off here. How do we avoid that kind of harm here?
That's a very valid question, Your Honor, and as Bowen said, that's a question for the legislature. It's not a question, with all due respect, for the courts to interpret.
Extend that, though. Extend that. If you're saying that necessity, right, is available with the use of deadly force, then if Judge McClure's client knows somebody's a serial killer, it's perfectly fine for him to walk up and shoot him in the head. That's necessity, right? Because if he doesn't kill him, he might go kill somebody else. So if you're going to say that, hey, the deadly force doesn't limit you to the legislature's statutory limitations, if you're going to say, no, the use of deadly force can be justified through necessity, then how do you deal with that situation? He's a serial killer, so I shot him in the head. Necessity.
One would hope that a jury would have more sense than to agree with that argument. But that's a valid
Juries
argument.
do all kinds of things all the time.
Yes, indeed, Your Honor. But that's a valid argument, and it's one that should be put before the legislature. It's not for any.
But hasn't it, though, when they said the use of deadly force is limited to just and only these circumstances? Have they not addressed that situation in that statute?
No, Your Honor, because they let 9.22 necessity defense continue. Had they been confronted with this argument, they might have done something else. But they didn't. And it's their prerogative, not, with all due respect, it's not the prerogative of the courts to say, well, the legislature didn't do this. There needs to be a plain legislative intent, but the legislature couldn't have.
Help me to understand something, how you started here about the harm with respect to not getting the necessity because of the weight, I think it was like 8 ounces on the wallet chain.
Yes, Your Honor.
How would that have been justified as a necessity that he had a wallet chain, so I had to stab him in the throat? I mean, how does that fit in necessity that it wouldn't fit under self-defense?
Because the jury could have believed that he was not attacked with deadly force. That this
Okay,
little chain that the state.
but the man had a chain, so it was necessary to stab him in the throat?
I'm sorry, I don't understand.
How would necessity have helped at that point in front of the jury?
Because if the if the jury decides that deadly force in defense of person isn't applying here, the chain couldn't have done it, which is what the state pushed at trial. If the jury decides that, but decides that Mr. DUDAS acted reasonably under the circumstances anyway, he's acquitted. That's the only thing I can.
I'm with you. I'm with you that far, no farther, but, okay.
Thank you. Another point is that one of the two defenses is entirely substantive. The other one has substantive and objective elements. Therefore, how they could possibly overlap, or how they, to any great extent, or how one could preclude the other, escapes me. They require different things. This is not one statute as sort of a catch-all. It's one statute, and the other statute requires different things. One cannot say if you meet the deadly force in defense of person thing, then you don't need the necessity defense. They're two separate animals. If the court has any questions, I'll be delighted to answer them.
Just your position on the standard of review here?
Oh, yes. I believe that the abuse of discretion standard technically applies. However, purely legal questions, if the judge answers them incorrectly, it doesn't apply the law.
Yeah, he has no discretion to get the law wrong.
Precisely, Your Honor.
Thank you.
Is that anyone else?
No,
Thank you all very much.
Thank you both very much for very fine oral arguments. We appreciate it. This case will be taken under submission, and the court will stand in recess.
Thank you, Your Honor.
Oyez, oyez, oyez. The Honorable Court of Criminal Appeals now stands recessed, subject to the call of the presiding judge.
I wonder if they find out.